You won't believe the nightmare I'm living through right now. Imagine waking up one day to find out your own neighbors, through the HOA, are suing you. Not for noise, not for trash, not for breaking rules you even knew existed. No, they're dragging me into court because apparently my house is blocking their view. Yeah, their view. This isn't a joke, and it's not some exaggerated headline. I've lived in my home for years, and suddenly the HOA claims I've violated something called a view easement. I didn't even know that was a thing. They sent me letters, photos, even diagrams, trying to prove that my house ruins their precious line of sight. And now they're demanding a remedy that could involve me tearing down part of my own property. Can you imagine? At first, I thought it was just another petty HOA complaint, like when they fined me for my shutters being the wrong color, or when they banned me from planting a certain type of flower in my yard. But this time, it escalated. When I got served with actual lawsuit papers, it felt like a punch to the gut. Fear, anger, frustration, all at once. And here's the wild part. The HOA believes they're 100% in the right. Meanwhile, I'm stuck fighting to protect my home, my sanity, and my future. So buckle up, because I'm going to walk you through this insane legal battle. And trust me, you'll never look at an HOA the same way again. This right here, this is the moment my Homeowners Association declared war on me. This stack of paper, heavy and cold in my hands, it isn't a friendly reminder to mow my lawn or a notice about the neighborhood potluck. It's a full-blown lawsuit, an instrument of legal warfare designed to break me. The heart of their argument, buried in pages of dense, impenetrable jargon, that my house, the one I had worked and saved for over a decade to afford, the physical manifestation of my family's security, the place my children called home, was illegally blocking a view. They didn't just claim I had broken a rule. They claimed I had violated something they called a view easement, a supposed legal right so powerful they believed it gave them the authority to force me to physically alter my own home. They were demanding, through the unblinking eye of the court, that I tear into the very structure that sheltered my family. They thought I'd get scared. They saw the fancy legal letterhead from a downtown law firm, the intimidating language, the chilling threat of court dates, liens, and financial ruin, and they figured I'd just roll over. They assumed I'd do whatever. They said, pay whatever they demanded, just to make the nightmare go away. It's what most people do, after all. The cost, the stress, the public humiliation, it's a powerful weapon. They were wrong. They had miscalculated. They had poked and prodded and threatened, assuming they were dealing with a sheep who would scatter at the first sign of wolves. They had no idea they were picking a fight with the wrong homeowner. In this video, I'm going to pull back the curtain on the entire ordeal. I'm going to walk you through the exact legal arguments that became my weapons, the obscure property, rights loopholes that became my shield, and the precise, documented steps I took, day by day, to not only dismantle their bogus, fraudulent lawsuit, but to make sure they could never, ever touch my property again. This is more than just a story about a dispute with a board of directors. This is the story of how I legally, methodically, and absolutely crushed my HOA. It all started, as these things so often do, with a dream. For my wife and me, the dream was this house. It wasn't a sprawling mansion or a cliffside villa with ocean views. It was a sturdy, welcoming two-story home on a street where you could still hear ice cream trucks in the summer. Quiet street, big, mature oak trees creating a canopy overhead, kids on bikes leaving chalk drawings on the sidewalks. It was everything we'd worked for, consolidated into wood, plaster, and shingles. The fact that it was part of a homeowners association was just a footnote, a single line item in a mountain of closing paperwork. I remember sitting at the title company's sterile conference table, a sea of documents stretching before us. The closing agent, a nice woman with tired eyes, slid a thick booklet across the table. "And these are the CC&Rs for the HOA," she'd said, almost apologetically. "Standard stuff. Just keeps the neighborhood looking nice. Initial here, here, and sign at the bottom. You sign it, you initial where you're told, and you move on, because you're high on the excitement of getting the keys. You assume it's all for the common good, right? Keeping the shared spaces tidy, managing the community pool, making sure no one paints their house neon pink. And for the first 2 years, it was exactly that. It was peaceful. I paid my dues on time, every time. I kept the lawn trimmed and edged. I brought the trash cans in from the curb on the same day they were emptied. I was a model citizen. I had precisely zero contact with the HOA board. And that's just how I liked it. It was a silent, mutually beneficial relationship. I paid them, they maintained the common areas, and we all went about our lives. Then, the first letter arrived. It was in a standard business envelope, the kind that usually holds a bill or junk mail, but it had the HOA's logo in the top left corner. I remember grabbing it from the mailbox on a sunny Tuesday, assuming it was a newsletter about new pool hours or a reminder about the annual block party. But as I slit it open and unfolded the single sheet of paper, the tone felt off. It was polite, but in that sterile, corporate way that puts you on edge, like an email from HR that starts with, "This is a confidential matter." It talked about a complaint from an unnamed neighbor regarding an obstruction of a view corridor. Vague, yet strangely specific, and it vaguely, passively, pointed the finger directly at my house. My first reaction wasn't anger or fear. It was just profound confusion. A view? What view? Our house is a simple 2-story home on a street full of other 2-story homes. We back up to a small, unremarkable patch of protected woods, not the Grand Canyon or the Pacific Ocean. I literally walked around my entire property, trying to see my own house from a new perspective. I stood in my backyard. I walked down the street and looked back. I tried to put myself in my neighbor's shoes. From the property behind mine, if you went upstairs, stood on your tiptoes, and craned your neck just right, you could, in fact, see a tiny, almost pathetic sliver of a distant green hill over the highest corner of my roof. Was that it? Was that the view corridor they were writing about? It seemed insane, delusional even. It had to be a mistake, a clerical error, a crossed wire in their complaint system. So, I did what any reasonable person would do. I tried to clear up the misunderstanding. I sat down at my computer, determined to resolve this with a simple, neighborly conversation. I can still picture myself typing it, carefully choosing every word to be as respectful and non-confrontational as possible. "Dear HOA Board," I wrote, "I received your letter dated date regarding a view corridor, and I'm hoping you can clarify a few things. As far as I am aware, there is no view easement on my property, and the letter didn't reference a specific bylaw that has been violated. Could you please point me to the exact section of the CC&Rs this pertains to and perhaps send over a map or diagram of the corridor in question? I'm, of course, happy to follow all community rules and want to get this sorted out amicably." I hit send, leaning back in my chair with a sense of relief. A simple, adult conversation would make this all go away. They would realize their mistake, apologize, and we'd all move on. I was so naive. I thought I was dealing with neighbors, with fellow homeowners. I didn't realize I was dealing with a board that had forgotten the difference between governing a community and wielding raw, unchecked power. That email wasn't the start of a resolution. It was the start of a war, and I had just handed the enemy a detailed map of my own reasonable, logical position. The HOA didn't email me back. They didn't call. For a week, there was only silence. I checked my email every day, then twice a day, expecting a reply that would clear everything up. The silence itself started to feel ominous. About a week after I sent my reasonable inquiry, Another official envelope showed up. This time, I knew it wasn't a newsletter. The tone had shifted dramatically. The thin veneer of corporate politeness was gone, stripped away, and replaced by firm, demanding legalese. My email, my request for clarification and specific rules, was completely ignored as if I had never sent it. Instead of pointing to a specific, documented view easement, they just gestured broadly to a catch-all clause in the CC&Rs, the covenants, conditions, and restrictions. It was a beautifully, terrifyingly vague phrase, something about the board having the authority to maintain the aesthetic character and harmony of the community. I would later learn from my lawyer that this is the go-to clause for any HOA on a power trip. It's a blank check. It means whatever they want it to mean, whenever they want it to mean it. It's a subjective standard they can apply at will, a cudgel disguised as a rule. This time, there was an attachment, a grainy, black-and-white printout from a map website with a crudely drawn red arrow scrawled on it, likely with a Sharpie before it was photocopied. The arrow started at the second-story window of the house directly behind mine, which, through a quick property search, I'd soon learn belonged to the HOA president himself, and pointed right over my roofline to that pathetic little sliver of distant green. That was their sacred view. It wasn't a view. It was a glimpse, a peek, a geographical footnote. And that's when the fog of confusion finally lifted, replaced by a chilling certainty. This wasn't about a view at all. This wasn't about aesthetic harmony. This was personal. This was about the HOA president. Let's call him Mr. Harrison, who had decided that his fleeting peek at a few faraway trees was more important than my family's right to the peaceful enjoyment of our own home. Still clinging to the hope of a rational outcome, I looked up his number and called him directly. I thought that maybe, just maybe, a one-on-one human conversation could diffuse this. The call was a masterclass in condescension. He talked down to me not as his neighbor, but as his subordinate, a disobedient employee. I tried to explain, calmly, that the house had been built like this a decade before I even bought it, and that nothing about the structure had changed. "The rules are the rules," he said, his voice just dripping with a smug, unearned authority that set my teeth on edge. "But what rule, specifically?" I asked, my frustration building with every evasive answer. "I've read the CC&Rs. Where is the view easement documented? Can you give me a section number?" "It's about the aesthetic harmony of the neighborhood," he repeated, as if it were a magic incantation that ended all debate. "The board has its standards, and your property is not in compliance." He made it crystal clear that the conversation was over. The board, meaning him, had decided. Click. He hung up. Soon after that infuriating call, the fines started. The first notice was a crisp, formal letter demanding $100 for failure to rectify view obstruction. Now, I had started doing my homework. In places like California, new laws like AB 130 were being enacted to curb HOA overreach, capping most non-health and safety-related fines at $100 and preventing them from tacking on exorbitant late fees or interest. They were following the letter of that law, but using it as a weapon of 1,000 cuts. A month later, another fine arrived, this one for $200 for continued non-compliance. The letters were becoming more hostile with bold, underlined threats like legal action may be pursued if payment is not received. They were meticulously building a paper trail, trying to invent a history of my defiance to justify their next move. That was the moment the last remnants of confusion burned off and were replaced by cold, hard anger. This was a shakedown. They weren't trying to solve a problem. They were trying to bully me into submission. They were counting on me being too scared of the legal threats, too busy with work and family, too financially drained to fight back. So, I started my own paper trail. I went to an office supply store and bought a heavy-duty 3-ring binder, page protectors, and a 3-hole punch. It felt like a declaration of war in itself. I 3-hole punched every single letter, every envelope they came in to document postmarks. I printed every email. I took dozens of high-resolution photos of my house, the property lines, the neighboring houses, and, most importantly, the so-called view from every possible angle. I started a log, a meticulous timeline of every communication, every notice, every threat, noting the date, time, and content. I documented everything because I had a sinking feeling that this binder was about to become my best friend, my shield, and my sword. I wasn't just a homeowner anymore. I was an archivist, an investigator, preparing for a siege. I will never forget the day I got served. It was a Tuesday afternoon, late in the day, the sky a hazy orange. I was bringing in groceries, my mind on dinner, and my son's homework. The mundane rhythm of family life. A nondescript sedan I didn't recognize pulled up to the curb. A man in a polo shirt got out and walked up my driveway, holding a thick manila envelope. He seemed hesitant. "Are you my name?" he asked, not making eye contact. I nodded, my stomach tightening. He handed me the packet. "You've been served," he mumbled, then turned on his heel, got back in his car, and drove away. My heart was pounding against my ribs like a trapped bird. I knew what it was, but the physical reality of it, the weight of the envelope in my hand, was a physical shock. It felt hot, radioactive. I walked inside in a daze, dropped the grocery bags on the counter, milk, bread, and a lawsuit, and went to the kitchen table. With trembling hands, I tore open the envelope. There it was, printed in stark black ink at the top of the first page. The Irvine Terrace Community Association, Vertautur, my name. Seeing my own name on a court filing felt utterly surreal, like I was watching a movie about someone else's terrible life. I sat at my kitchen table for over an hour and read every single word. It was page after page of dense, convoluted legal jargon, but the message was brutally clear. My own neighbors, the people I waved to on the street, were suing me. They accused me of violating the CC&Rs, breaching my contract with the association, and creating a private nuisance. The remedy they were demanding from the court? An injunction. It was a word I only knew from television. They were asking a judge to issue a court order forcing me to remedy the obstruction. What did that even mean? Tear off a section of my roof? Demolish an entire portion of my house? The language was deliberately vague and terrifying. It was a legal sledgehammer aimed directly at the foundation of my family's security. The fear was real and suffocating. The thought of the cost, the endless stress, the humiliation of having my life dissected in a public courtroom, it was overwhelming. I spent that entire night staring at the ceiling, my mind a raging storm of anxiety and white-hot anger. They had pushed me, fined me, ignored my attempts at reason, and now they had invaded the sanctity of my home and my life with a legal battering ram. I thought about giving in. I calculated how much a lawyer would cost versus whatever it might take to just, I don't know, flatten a section of my roofline? Appease the petty tyrant on the hill behind me? But every time my mind drifted towards surrender, the anger surged back, hot and clarifying. This was wrong. This was a disgusting, sickening abuse of power by a man on a tiny throne, a man who had weaponized a neighborhood association to settle a personal grievance. That night was my turning point. The fear was still there, a cold knot in my stomach, but it hardened into something else. Resolve. They thought I would fold. That was their big miscalculation. I wasn't going to be bullied into architectural mutilation. I was going to fight. And I was going to win. My first step wasn't calling a lawyer. It was hitting the books. Hard. I spent the entire weekend glued to my computer. A man possessed. I dove down the deep, complex rabbit hole of property law, HOA regulations, and legal precedents in my state. I searched for everything I could think of. HOA lawsuit view obstruction. Homeowner rights against HOA. View easement requirements, California. Burden of proof, aesthetic harmony. I read dry legal articles, passionate rants on homeowner forums, and digested actual court case summaries. And that's when I found my first critical breakthrough. Aha! Moment number one. In my state, and as I learned, in almost every state, there is no automatic or natural right to a view, light, or air. It's a cornerstone of American property law. Your neighbor can't just stop you from building a second story because it blocks their sunset. Unless there's a specific, written and officially recorded agreement called a view easement. A right to a view isn't something that just comes with the deed like the land itself. It has to be formally and legally created, agreed upon by the affected property owners, and recorded with the county for it to have any legal power. The HOA's entire case, the foundation of their lawsuit, was built on this view easement. They had even used the term in their initial letters. But what if it was all a bluff? What if they were using a legal term of art without possessing the actual legal instrument? What if it didn't even exist? This discovery was the first real crack in their armor. Their case wasn't built on solid law. It was built on a foundation of assumptions. The assumption that I'd be too ignorant of the law and too intimidated to question their authority. Armed with this kernel of knowledge, I knew I needed a professional. I wasn't looking for just any real estate lawyer. I needed a specialist, an HOA slayer. I spent a full day calling law firms, explaining my situation over and over. A few sounded bored, suggesting I should just try to settle. But then I found one. His website was no frills, but it was filled with articles about fighting HOA overreach. When I explained my situation, the lawyer on the other end didn't sound surprised. He sounded grimly familiar with the playbook. Ah, the aesthetic harmony clause, he'd said with a sigh. The last refuge of a board with no actual case. I went in for a consultation, my meticulously organized binder of evidence tucked under my arm like a football. I laid out the whole story. The first letter, my polite email, the escalation, the fines, the condescending phone call, the lawsuit. He listened patiently, flipping through my documents, his expression unreadable. When I finished, he leaned back in his chair, and a slow smile spread across his face. "Well," he said, "their first big mistake was suing you. Their second was you being disorganized." He confirmed my late-night research. "They're acting like they have a view easement, but they haven't produced one in any of their correspondence or in the lawsuit itself. The burden of proof is on them, the plaintiff, to prove this right exists. And I'll tell you right now, a vague clause about aesthetic harmony is not a view easement. It's not even close." Leaving that office, I felt a colossal weight lift from my shoulders. The sun seemed brighter. It was still my fight, but now I had an ally, a strategy, and a sword forged from actual law. The fear was gone, replaced by a cold, determined focus. The HOA had declared war. Now it was time for my counterattack. The first official phase of a lawsuit is called discovery. It's a wonderfully straightforward concept. Both sides have to show their cards. No hiding evidence, no ambushing your opponent in the courtroom with a surprise witness. It's a forced transparency, and for a party built on bluffs and vagaries, it's a terrifying prospect. My lawyer and I drafted our first formal request for production of documents. This wasn't a polite email. This was a legal demand, backed by the authority of the court. And we were surgical. We didn't just ask for everything. We asked for specific, numbered items, the original, recorded covenants, conditions, and restrictions filed with the county upon the development's creation, any and all amendments, addendums, or changes made to those CC&Rs since their initial filing, all recorded plot maps, land surveys, and easement documents pertaining to the community, specifically demanding any document titled referencing or purporting to create a view easement or view corridor over my specific property lot. The complete, unredacted, and board-approved minutes from all HOA board meetings where my property, my address, or my name was discussed. And the big one, the one we suspected they didn't want to find, a copy of the original architectural application and, crucially, the signed approval for the construction of my house from the HOA's own Architectural Review Committee. Their lawyer responded with classic, predictable delay tactics. Weeks turned into a month. The excuses were flimsy and frustrating. We're in the process of compiling the documents. It's a significant amount of paperwork spanning many years. They were trying to bleed me dry, to make the process so slow, so frustrating, and so expensive that I would give up from sheer financial and emotional exhaustion. We didn't back down. My lawyer filed a motion to compel, which is the legal equivalent of telling the judge that the other side isn't doing their homework. That got their attention. A few weeks later, 2 massive, banker-sized boxes arrived at my lawyer's office. It was a deliberate document dump, a malicious compliance tactic. Thousands of pages of paper, disorganized, unindexed, unstapled, meant to bury us in useless information and obscure the few pages that actually mattered. They thought we'd never have the time or the patience to go through it all. They were wrong again. My lawyer and I blocked out an entire weekend. Fueled by gallons of coffee, takeout pizza, and a shared sense of righteous mission, we went through every single piece of paper. We sat in his conference room surrounded by stacks of paper, a paper fortress of the HOA's own making. We read years of tedious meeting minutes about holiday decorations and arguments over pool furniture. We read financial reports, vendor contracts, and landscaping bids. We read every word of the documents that governed our community, from the driest articles of incorporation to the most mundane neighborhood rule. And then, deep into our second day, we found it. Moment number 2. The smoking gun. Deep within the primary original CC&R document from the early 1990s, we found the section titled Easements. My heart pounded in my chest. There it was, in black and white. There were detailed easements for utility companies to access their lines. There were easements for emergency vehicle access. There were easements for stormwater drainage between properties. But there was absolutely nothing, not a single word, not a phrase, not a hint, about a view easement. The central legal right their entire lawsuit was based on? The thing they were suing me over? It was a complete and utter fabrication. My lawyer just looked at me over the top of his reading glasses and smiled. He tapped the page with his pen. "This," he said, "is the ball game." But it got even better. Digging further through a box of jumbled architectural files, we found a brittle, dusty file folder labeled with my street address. My breath caught in my throat. And inside that folder was the Holy Grail. Aha! Moment number 3. The coup de grace. It was the original architectural submission package from the home builder dated over a decade ago. It contained the complete blueprints for my house. Every dimension, every exterior material specification, the exact roof pitch and height that they were now calling an obstruction. And stapled carefully to the back of the application was a single sheet of paper. On it were the signatures of the 3 members of the Architectural Review Committee at the time, including, with a breathtaking stroke of irony, a younger Mr. Harrison. And stamped across the top of the approval form in big, faded red ink was one word: approved. I just stared at it, speechless. They were suing me over a feature of a house that they themselves had officially and formally approved in writing. Their lawsuit wasn't just baseless and built on a non-existent legal right. It was a direct, documented contradiction of their own official records. It was incompetent. It was negligent. And it was the final, unpullable nail in their legal coffin. Our case was now airtight. We had them on the facts. We had them on the law. And now, we had them on their own breathtaking incompetence. The siege was about to be broken. It was time to go on the offensive. With our evidence locked down, certified, and ready, my lawyer explained we had a choice. We could drag this out to a full, expensive, and emotionally draining trial, or we could go for a swift knockout punch. I chose the punch. We filed a motion for summary judgment. In simple terms, this is a legal maneuver where you ask the judge to decide the case right then and there without a trial. It's a bold move, because you're essentially telling the court, Your Honor, the undisputed facts are so overwhelmingly stacked in our favor that there is literally nothing to argue about. Let's end this now. It's a high bar to clear, but we weren't bluffing. We had a royal flush, our motion, a thick document that made my heart swell with pride, laid out 3 simple, irrefutable points, each supported by an exhibit from their own document dump. No right to a view exists in law. We cited the established legal precedent in our state. A homeowner has no automatic or natural right to a view unless it is specifically and legally created in a written instrument. No view easement exists in the governing documents. We attached the complete certified copy of the HOA's own CC&Rs, highlighting the easements section and proving the complete absence of any language creating, granting, or even mentioning a view easement. Their central claim was based on a right they simply did not possess. The HOA had previously approved the structure. This was our kill shot. We attached a certified copy of the original building plans and the signed, stamped approval form bearing Mr. Harrison's own signature. We argued that the legal doctrine of estoppel applied, a powerful concept that essentially means the HOA was prevented, or stopped, from complaining about a situation that they themselves had previously approved. You don't get to say yes on Monday and then sue someone for it on Tuesday, a decade later. The HOA's lawyers filed a weak, rambling response. They couldn't refute our facts, so they fell back on emotional, subjective arguments, leaning heavily on that vague, aesthetic harmony clause. They tried to argue that their feelings about the neighborhood's attractiveness and their duty to one homeowner's desire for a glimpse of a hill should somehow override concrete property law and their own written approval. It was a desperate, flimsy defense. The day of the hearing arrived. The courtroom was a small, quiet, intimidatingly formal room. I sat with my lawyer at one table, my binder on the table between us. Mr. Harrison sat with his expensive lawyer at the other, looking smaller and less confident without the buffer of angry letters and his position of power. He wouldn't even look at me. The judge, a no-nonsense woman in her late 50s, made it clear from the outset that she had read everything both sides had submitted. The HOA's lawyer went first, trying to paint me as a rogue, uncooperative homeowner, disrupting the peaceful community. He talked about property values and the board's solemn duty. He never once used the words view easement, because he knew he couldn't prove it existed. It was all smoke and mirrors. Then my lawyer stood up. He didn't make a grand, sweeping speech. He just calmly, factually, and devastatingly walked the judge through our 3 points. He presented the law. He presented the CC&Rs. And then, with just a touch of courtroom flair, he placed the signed approval form on the projector. Your Honor, he concluded, the plaintiff, the HOA, is suing my client for building the exact house that the plaintiff approved, based on a legal right that their own governing documents failed to establish. This lawsuit is not just meritless, it is frivolous, it is punitive, and it is a profound waste of this court's valuable time. The judge listened, her face an unreadable mask. When my lawyer sat down, she turned her gaze to the HOA's attorney. Her voice was quiet, but cut through the silent room like a razor. "Counsel," she began, her eyes fixed on him. "Let me see if I understand the core of this. Your client, the Homeowners Association, approved the construction of this specific home, correct?" The lawyer stammered, shuffling his papers. "Well, yes, Your Honor, but—" "And," the judge cut him off, holding up a hand, Your client's governing documents, which form the contract here, do not contain a recorded view easement benefiting your client's president, do they? Not in those specific words, Your Honor, but the aesthetic. The judge held up her hand again, stopping him cold. She took off her glasses and looked directly at Mr. Harrison, a predator singling out his prey. You are suing this man for a substantial sum of money and a court order to modify his home, for building the very house you personally gave him written permission to build, based on a legal right you do not possess. Is that the long and short of it? Dead silence filled the room. Mr. Harrison stared at the polished surface of his table, his face turning a deep, blotchy beet red. The judge picked up her gavel. The defendant's motion for summary judgment is granted. This case is dismissed, with prejudice. She banged the gavel once, a sound like a gunshot that echoed in the quiet room. And counsel, she added, looking at my lawyer, I will be entertaining a motion from the defendant to recover attorney's fees from the plaintiff. That was it. Over. We had won. Completely and totally. I let out a breath I didn't realize I'd been holding for 6 months. I looked over at Mr. Harrison. He just stared ahead, a defeated, diminished man. The Goliath of the HOA, with all its presumed power and authority, was brought down by the simple, undeniable, documented truth. In the end, the HOA didn't just lose the case. The court ordered them to pay every single dollar of my legal fees, which were substantial. Their attempt to bully me with the threat of legal costs had backfired spectacularly, costing the community, the dues-paying members themselves, tens of thousands of dollars for a lawsuit based on a lie. At the next annual meeting, there was a reckoning. Homeowners, now aware of the full story and the financial cost of the board's vendetta, were furious. Mr. Harrison was not re-elected president. He wasn't even re-elected to the board. He was quietly and unceremoniously voted out. The moral of my story is simple. Do not be intimidated. HOAs often operate on the powerful assumption that you don't know your rights and that you are too scared, too busy, or too financially constrained to fight back. But their power is not absolute. It is strictly limited by the law and, most importantly, by their own governing documents. Recent laws in states like California are also pushing for more transparency and accountability from HOA boards, giving homeowners more power than ever. Read your documents, know your rights, and if you receive a bogus claim, document everything and find a lawyer who knows how to fight back. The law and the facts are often on your side. Your home is your castle. It is your sanctuary. You have the right to defend it. If you've had your own HOA nightmare, I want to hear about it in the comments below. I read every one, and I know how cathartic and empowering it can be to share these stories and know you aren't alone. And if you want to see more stories of homeowners standing up for themselves and winning against overwhelming odds, make sure you hit that subscribe button. Thanks for watching.